Well, thanks, Michelle, for the introduction. I appreciate it. As Michelle said, I'll be trying to provide some clarity given what's going on currently with the COVID crisis and all the changes that are going on a rapid basis. Like Michelle said, my main practice is in employment law defense. So I mainly represent employers in employment cases or consulting. So they don't have employment cases. That's mainly what I do. I also practice in trust and estate litigation, which again, that doesn't really overlap with employment. It's just something else I do. So let's get started. Let's first talk quickly about what topics we're going to cover. So first off, and I think this is the most and foundational, as we go along, you'll see why that's the case. So first is COVID-related agency guidance. And the reason why that is the case, because generally if you're following the guidance, I think you're going to be very safe in this environment. And luckily the guidance is not overly specific, not onerous, fairly easy to follow. And so if we follow the guidance, I believe that we will maximally protect ourselves, and we'll see why that's the case as we go forward. So we'll go through the CDC's recommendations and OSHA's recommendations. First, kind of set a foundation of what specifically related to COVID is the government asking us to do. And then we'll go from there. So second, we'll talk about the potential liabilities businesses have to visitors or customers. So this would be folks who come into your facility or to your office who don't work for you. Is there a liability to those folks? Possibly yes, certainly possibly yes. What is it? How do we analyze it? How do we minimize it? So that's what we're going to cover regarding visitors. Just below that, what are our potential liabilities for to employees? So similar scenario, but a little bit different legal analysis. What is a company's liability to its employees potentially related to COVID-19? And when we're talking about this, we're generally talking about someone, visitor, employee, et cetera, someone contracting the virus. That's the main thing. But just because they contracted at your facility or they're your employee doesn't mean you have liability, but it can, and we'll get into that. So that's the first two, I think, top of the list questions for employers, businesses. What is my liability to visitors? What is my liability to employees? Then underneath that, what about employee refusals to return to work? So that's happening quite a bit now from what I gather from my clients, is that offices are opening back up. People are being asked to come back to work, and some people are not complying with those requests. What is an employer or business to do if the business opens back up, the person's offered to come back, and they refuse? How do we handle that situation? And lastly, which is related, a furlough concern. So either selecting people for furlough or selecting people to return from furlough. What are some blind spots, potential liability traps for employers? And I'm kind of particularly worried about that one, and we'll discuss why when we get there, just because we could be so focused on the business and who to bring back for the business purposes. It may lead to a blind spot and make some choices that may seem logical, but may lead to liability that we don't want. So first off, let's do a poll question. We'll have a number of these polls throughout, and let's do the first one. The first question is, are your employees back in the office yet? And we'll give it a little bit to answer. It's like a percentage is rapidly growing here. So we're about at 2/3 voted. So give a couple more seconds and then we can stop it. All right, we're above 70%. So we can go ahead and stop the poll. I think I can do that. All right, so the results are 50% people of the offices, at least on this call, are fully staffed back in the office. As you can see, 40% are yes, but reduced number of staff modifications. There's actually no one on this call, at least, that voted that we don't have anyone back and don't know what to do yet. So it looks like most people, and that's probably fairly consistent with Texas. I know not everybody on the call is from Texas, but that's probably pretty consistent. So that's good for us all to know. And that's what I would have assumed, and that's kind of how I prepared. So I think we're on the right track. So this is what we should be thinking about. Let's go to the next slide. Okay, let's go first to the agency guidance I mentioned earlier. So first things, most employers probably are doing health screening for their employees as they come in. It's not strictly required from anything I've seen in the recommendations. However, it is generally recommended that you do some sort of health screening for your employees as they come into work, generally speaking. So the main thing is you can actually take their temperature. Now, there's the wand that you do over the forehead. Any other way you can take the temperature, make sure you do it in a sanitary way to make sure that we're not passing on the virus if someone has it, or anything else for that matter. But people, I think, just use common sense on that. But the good news is you can take employee temperatures as they come to work. Under other guidance, that's technically a health exam or medical exam. Guidance clearly says you can do that. You can take temperatures when employees come into work. Again, the number that's been floating out there from the recommendations is fever over 100.4 degrees. So if somebody comes in, they have a fever of 101, we'll get to what to do, but generally that person should be sent home. But there's other things you can verify too, other symptoms. For instance, coughing, shortness of breath, chills. These are all things the CDC specifically mentioned. So someone comes in, get them to fill out a form verifying they haven't been experiencing these symptoms since the last time they were at your office or your facility. What do you do with that paperwork, by the way? As you may have already guessed, what you should do with that paperwork is store it in the employee's confidential medical file, not in their general personnel file. So, if I'm coming in your office Monday through Friday and I have a verification every day, I come in, my name, I'm checking boxes. Yes, I verify I haven't experienced these symptoms since yesterday if I came in the day before. Since Friday, if it's a Monday, you document my temperature. Keep those, but put them in the employee's confidential medical file, not in the general personnel file. So that's the first step. That's the first level of defense, so to speak. The CDC also gives a good amount of procedural recommendations for businesses. Now, these are the things that you've been seeing in the news, you've been experiencing as you go in and out of other businesses. But let's go through some of the specifics. Again, not overly specific, not overly onerous. These are things that, if possible, businesses can do to really help protect themselves, their customers, and their employees. So the first thing is, there's been countless memes and jokes about social distancing, and many of them are funny, I have to admit. But whatever we can do as businesses to increase the distance between employees and customers, et cetera. So whether that be, I know there's some offices, and we'll get into risk levels of different types of businesses, but for example, here at our office, we have a break room where people can eat lunch. If we had a recommendation that said, look, just eat lunch in your office for the time being, and that way there's less traffic in that area, that everyone's kind of separated in their own office or own cubicle, that would be a pretty logical recommendation to increase the physical distance, even though we're all at work. Other things you've probably seen, and we'll get into this in a minute, but floor markers, those are pretty common. For instance, go to a bank and you'll see the X's on the floor, how far away you should be in your line, grocery stores, et cetera, all these sorts of things. So those are easy things to do. People are generally following them. So distance markers, any partitions you can have as well. So I know that's not always feasible, but some places it is feasible. Behind a window, behind a partition, spacing people out, partitions, floor markers, distance. We'll get into a risk level, like I said, whether you're a business that has people dealing with the general public or not, depends on whether you need to do that. But the first thing is distance, partitions, floor markers. The other is cleaning and disinfecting. So again, that's sort of common sense, but sometimes if you didn't brainstorm what areas in your office would be high touch areas, you may miss one or two. I know that when I thought about it in our office, there were a few areas where I was like, well, I maybe wouldn't have thought of that unless I really sat down and thought about it for a minute, but that is probably a high touch area that would need to be cleaned and disinfected. So the general recommendation is to clean and disinfect those areas at least once per day. But logically speaking, the more high traffic it is, maybe the more frequently you should do it. Have someone assigned to make sure that's done, because if we all assume someone's doing it, no one may be doing it. So assign someone to do it, clean and disinfect high touch areas. Again, we'll get into maybe putting this in a written plan in a minute, but that's pretty common sense. Probably most people are doing it. Hand washing, we've all become hand washing experts over the past few months, 20 seconds soap and water. So actually really good video. I think it was put out on a YouTube channel, Vice or Vox or something like that. And they actually showed the amount of germs that could be on your hand after 10 versus 15 versus 20 seconds of soap and water. And it convinced me, at least. I was like, okay, that's pretty convincing, any kind of visual like that. So anyway, guidance to employees and visitors about hand washing. I know here in the Regents building, we not only have things in our break room, but you see it also in the restrooms, et cetera, saying it's better to, wash with soap and water for 20 seconds, less effective if you use the hand sanitizer. Both are acceptable. Guidance on that, signs, most people are doing it anyway, but just to help remind, because you can get in a hurry sometimes and not do the full 20 seconds. So that sort of thing, hand washing, flexible scheduling, kind of what I mentioned earlier about maybe designating high traffic areas to be only used at certain points. But one easy example would be this. If you had employees that have 80% of their job can be done remotely, but 20% they have to come into the office to complete it. Now, let's say I'm that case, and let's say that a couple of my coworkers are. Well, here's an easy fix. Telework for your 80%. If you have to come in for your 20%, that's fine. But let's try to schedule my 20% of my time at the office and my other coworkers, for instance, so we minimize the amount of people who are there at one time. And the idea is to minimize face-to-face contact, which we'll get. But those are things, if you think about them, you can plan them, and you can minimize traffic, that sort of thing, at your office. Now, mask, general office workers aren't required to wear masks. In fact, OSHA even says when we get to the low risk category, don't really need to request masks. You can ask people to wear masks. There's nothing wrong with that. If you're dealing with the general public, though, you generally should be wearing a mask. You go to grocery stores, you go to fast food restaurants, et cetera, you'll notice most people are wearing the mask. So again, but wear the mask over the nose and mouth, et cetera, but all becoming experts on that too. So those are the general procedural recommendations that the CDC has given. Here's an issue where the rubber starts meeting the road. What do you do when you have an employee who's symptomatic, who's suffering symptoms? This is coming up more and more, although Smith County's numbers aren't bad. They're pretty good, but you never know what will happen, of course, and not everybody in this call is from Smith County. But the first thing you want to do is separate that employee experiencing symptoms. So this would be coughing, chills, fever, et cetera, if they're at work. If they're at work, separate them and send them home as soon as you can. That's the first thing to do. You want to disinfect the areas that they've been around for 15 minutes or more in close contact. The general recommendation is to wait 24 hours. So let's say that I'm symptomatic here at Ramey Flock. First of all, I should be told to, report this to the other people here. So I say, hey, look, I'm symptomatic. I'm going to go home, close off my office for 24 hours, and then disinfect my office. I think the 24-hour waiting period is the idea that whatever virus germs there are in my office would be less able to infect other people after 24 hours. Separate it 24 hours, disinfect it. You want to also notify other employees who are around this employee, and it's close contact is the term used in the guidance. Now, what is close contact? The general rule of thumb that I found is within 6 feet of this person for 15 minutes or more. So really, honestly, in my situation, and many of you on this call, that would actually be no one. No one is within 6 feet of me for 15 minutes or more during the day. But let's say there would be, for some reason, let's say that that was the case. Well, Ramey Flock should notify that employee that you possibly were exposed to someone who really symptomatic. Now, at a smaller office like ours, it would be obvious who that is. And that's okay, but don't give the name of the person. And we'll talk about that when we talk about people who tested positive. Don't give the name when you notify the potentially exposed people. So you want to identify those people. Now, what about me in this situation? When can I return to work? The general rule is given by the CDC is I have to have 3 days of no symptoms, in particular fever. 3 days of no symptoms, plus there has to have been at least 10 days since my first symptom. So let's have symptoms today, and then 12 days from now, it's been 3 days, I have no symptoms, and it's been more than 10 days since my first symptom, which would be today. In that situation, I can return to work. Separate, send home, notify exposed employees, and then once they're asymptomatic for 3 days and more than 10 days have passed, or at least 10 days have passed since the first symptom, then they can return to work. What about an exposed employee? We talked about notifying potentially exposed employees of this. Or what if, let's say that I say, hey, my wife has contracted it. I don't have any symptoms, but my wife has contracted it. So again, a symptomatic household member, a symptomatic spouse, or again, someone you've been within 6 feet of, or the employee's been within 6 feet of for 15 minutes or more, then in that case, you would be considered a potentially exposed person. So what does the employer do? You should send that person home for 14 days. They should self-monitor their symptoms. If they haven't come in, they're calling and saying, hey, my son has contracted the virus. What should I do? Stay home for 14 days, monitor your symptoms. If they become symptomatic, we go back up to the list above, right? So again, they can come back to work, but it's once they're 3 days of no symptoms, 10 days since first symptoms. If they remain asymptomatic for 14 days, which is not uncommon, they can return back to work after the 14 days. So those two issues, symptomatic and exposed, they're treated similarly, but if you follow these fairly simple guidelines, you're doing what the CDC recommends and you're protecting yourself, your business, and other employees and customers as much as you can. So let's go to the next slide, and this is a poll. Have you had symptomatic employees? All right, the numbers are jumping up pretty fast here. Looks good so far. Let's see, give it a few more seconds. Okay, so we have 60% that have voted, and only have 3 with a yes when it comes to symptomatic employees, and 84%, I can share the results here, show up, there you go. Overwhelming majority have no symptomatic employees. Well, that's certainly good. I think other areas of the country would maybe have that flip depending on where you are. So that's certainly a blessing for us here. And again, assuming most folks are in East Texas, which I'm sure is the case. So good, we haven't had to deal with this, but now I think we have a better idea of how to deal with it. So let's continue. Now, what about an employee who's tested positive? So if it's more than 7 days since they've been there, if it's tested positive, then you just tell them and anyone else that was around them to monitor their symptoms. You don't have to disinfect the area. From when I read it, it's been more than 7 days since the person has been there. Again, though, if you know that someone has tested positive, don't tell other employees the name of the employee who's tested positive, even if you're coming to them and let's say there's only one other person I've been around for 15 minutes or more yesterday and I test positive today, and you go tell that one employee, hey, you were exposed to someone yesterday who was tested positive for COVID, they're going to be able to figure it out. There's nothing you can do about that. Don't give the name, even if it's obvious. Don't confirm or deny, just don't go there. Now, you can give the name of the person to a public health agency. You can do that, but you shouldn't give it to the other employees. Again, we're going back to the same issue of symptomatic employee. If I test positive, close off, and I was at work today, close off my area I worked in for more than 15 minutes, close it off for 24 hours, be clean and disinfected after the 24 hours, and reopen it. Again, tell others to monitor their symptoms. Again, you want to identify and notify potentially exposed employees, the same issue we talked about. Who was within 6 feet of me for 15 minutes or more in that situation, go notify them, treat them as an exposed employee. They monitor their symptoms. If they're symptomatic, they're treated like a symptomatic employee. So we have a good framework to deal with this situation. Now, what about the infected employees return to work? When can they return to work? Now, this is a little bit frustrating for me because there's a little bit of conflicting information up there, but I think it is overall reconciled. The recommendation from the EEOC that I've read, CDC, OSHA, they all recommend not requiring a note from the healthcare provider or a test to confirm the person is safe to return to work or that they don't. But they give guidance if tests are available for this person. So I think that's the way to handle it. Don't require it. Although some EEOC guidance saying you can test them yourselves if you can. I don't think testing is available enough yet in the U.S. to be able to test as the employer, but EEOC guidance says you can if you have that availability, which most of us will not. But if the employee is not going to be tested before they come back to work, we treat them like a symptomatic employee. So they can come back when they're 3 days in those symptoms plus 10 days since their first symptoms. Same method we used earlier. Now, what if they will be tested? If the employee will be tested, then we want no fever or other symptoms, at least have the symptoms reduced. And the key thing is you want 2 negative tests at least 24 hours apart. So that's 2 consecutive negative tests separated by 24 hours. So I test negative right now. Tomorrow at noon, I test negative again. I'm safe to come back. And again, I think the reason, or from what they've said, and it makes sense to me, the reason why they don't really want employers requiring notes from healthcare providers and negative tests from employees to return to work at this point, I think is the worry, and this may change soon, but the current state of things is they don't want healthcare providers to be overloaded with these types of requests when they're trying to treat patients, et cetera. Same thing with the testing. Is that the best use of testing when they're scarce? Maybe not. As tests become more available or the cases decrease in frequency, that may change. That's the general recommendation now. They say, don't really want you to be asking or requiring notes and negative tests from employees. But if you do have the tests available, 2 negative tests, 24 hours apart. Okay, next is OSHA guidance. So you've probably seen this. OSHA has, they've kind of tiered their guidance based on the type of business that you are. And they range from low to medium to high to very high risk. And their recommendations for you as a business depends on how you're ranked on this scale. So first off would be low. Low would be office workers with infrequent contact with customers and coworkers. So again, a law firm, accounting firm, banks that don't deal with the general public, lots of offices would qualify as low risk. Key thing here that bumps you from low to medium is contact with the general public. So let's go up to medium. Generally, it's going to be medium risk business will be a business who has contact to deal with the general public. High and very high, we're not going to talk about them very specifically because those are generally going to be healthcare workers. So high would be healthcare workers who are potentially around or even sometimes treating COVID patients. Very high would be actually those workers who are doing intubations, et cetera, who have to wear the full mask, goggles, et cetera, gloves, and doing intubations where the aerosol spread is very likely. So there's different recommendations for high and very high. And if you're a healthcare provider, and you're in that scenario, you probably know those better than me. But let's go on to the low risk first. And so OSHA gives some guidance, and there's a good PDF. It's sort of long, but it's usable. I would look it up. I think it was put out maybe a month ago, maybe 2 months ago at this point. It's very good. It's very helpful. I'm trying to summarize it for us here, but I don't discourage you from looking it up. First thing that they recommend is that employers develop a plan. And in the plan, the written plan, you want to assess the risk of exposure and measures you can take to decrease that risk. So this is kind of what we've been doing so far on this call. You've probably already done this in your business. Now, I would recommend, and I think they do too, have a written plan. Even if the written plan is just going to be regurgitating the CDC guidelines and the OSHA guidelines, that's fine. Have a written plan. And I gave Coleman and Michelle a link to the state of Minnesota put out a COVID preparedness plan in writing that they recommend for employers. I didn't find one for Texas. I didn't find one for most states, but I saw the Minnesota one. I thought it was a good template to build on to come up with your own written plan on how to deal with this. So I would add in some of the specifics from the CDC recommendations that I've talked about, dealing with symptomatic employees, exposed employees, quarantining the areas 24 hours, all that stuff. But it's a good basis. I think Coleman's going to share the link if he hasn't already. And you can use that as a template to start with if you don't already have one, or even if you want to modify yours, a written plan here to assess the risk and how to reduce exposure. Now, if you notice that the topics here, they're going to be very similar. And in fact, the OSHA's kind of pointing, hey, go look at what CDC says for all employers. So it's the things we've already discussed: how to handle symptomatic and exposed employees. What procedures can your business incorporate to decrease the risk? The whole thing is we want to decrease minimum physical contact, minimize that if we can. So hand washing, reporting symptoms, respiratory etiquette. It kind of seems, I don't know, a little childish at times, but it's a good reminder, cover your sneezes and your coughs, wash your hands afterwards, disinfect, those sorts of things, keep distance. Again, same sort of issues, flexible hours, flexible scheduling if you can. It's very similar. It's kind of referring back to the CDC guidance we covered. So this is for all employers, they recommend, all of them, even the low risk ones. So the low risk employers, again, their guidance for low risk businesses, this would be office workers without much contact to the general public. Follow the guidance we just covered for all employers. There's no additional PPE recommended for those workers. So I'm not wearing a mask now. I can, if we wanted to, that would be fine. They don't necessarily recommend it for the low risk employers. Now, medium risk, again, this is those that deal with the general public. They say, okay, follow all the stuff we mentioned for the general low risk employers. But then we add some others, right? Because you're dealing with the general public now. Now we're into the physical barriers where feasible. We're into the markers on the ground. You want to consider, especially the employees who are actually interfacing with the public, they wear the mask. I've seen gloves used and not used, and I think obviously the common sense answer would be that if you use the same gloves all day, it's just like not having a glove. So maybe some guidance on changing gloves, washing hands, et cetera. But you want to consider those things. You want to maybe limit access to certain areas. That way it's easier to control and monitor. You don't want it too small where you're cramming people, but you may want to kind of streamline things to where you can control this smaller environment that the public has access to, so you can monitor, clean more regularly, et cetera. The goal, though, obviously, is to minimize face-to-face contact. So if you're a business, medium risk, consider the general recommendations plus the barriers, mask, gloves, floor markers, all these sorts of things, flexible scheduling, which all of us can use, but medium risk, you want to give that a little bit more thought. So next up, let's get into liability here. So what is your liability to visitors? So this would be a non-employee coming, a patron of your business, or someone just browsing. Now, again, if we're following the recommendations we just discussed, I think your liability is going to be very minimal because you're following your duty to the general public by following these guidelines. Now, will CDC come in there and write you up of the citation, or OSHA? From what I read, OSHA isn't, at least hasn't been, at least the last I read, going in and really citing people for these things yet. They may start tomorrow, I don't know. But that's not your biggest worry at this moment. Your biggest worry is if you're not following these and somebody gets sick. So let's go. There's kind of two ways that you can have liability for a visitor coming and contracting the disease. So what are we talking? We're talking about somebody coming to your facility, your business, and contracting the disease, and then they sue you and say, it's your fault that I have the disease. And this could be very serious health condition, right? So this could be a bad case for us as businesses. Now, there's two ways, and you know, I'm talking Texas specific, but this law is not going to vary much state to state. This is old, established tort law. This is meat and potatoes, personal injury type cases. So first it would be a negligent activity type case. So think of this as an ongoing activity. So in this situation, the defendant owes the plaintiff a duty to not harm them. The defendant breaches the duty in some way. The defendant's breach causes the injury, and that's going to be important, and then the plaintiff suffered some harm. So think of this. If I'm visiting a paint store, I'm going to pick on paint store, I'm visiting a paint store, and an employee drops a can of paint on my head. Well, that's a negligence claim, right? He shouldn't have dropped, he had a duty not to drop it on my head, and he did, and maybe now I'm hurt. So this would be for an ongoing activity. I don't think that most claims regarding a visitor contracting COVID will be this. I think this type would be really more or less, you'd have to show an employee actually like sneezing or coughing on someone for it to be an ongoing activity. Because I think it's going to be the second category, which is more of a premises claim. So think slip and fall. That type of case. So here, the defendant had an actual or constructive knowledge of a dangerous condition, maybe community spread of COVID. The condition posed an unreasonable risk of harm. The defendant did not, which is us in the business, did not exercise reasonable care to reduce or eliminate the risk. That could be our issue, right? Not following those guidelines, and our failure caused the plaintiff's injuries. So think of this: if I'm spraying something on the ground to, clean the floor to have polished concrete, an hour later somebody comes in my store, I don't have wet floor signs, they slip and fall. That's not an ongoing activity like my paint example, but it is a condition. I knew about it. I didn't do anything to minimize the risk. Somebody hurt themselves. I think most cases, such as they are, will be this type. So you don't have proper distancing, you don't have proper barriers, you had employees without masks, etc. And our policies and our employees following those policies will be our best defense on this. But I think they're going to be more premises type claims. And from what I've read online, that seems to be the majority opinion as well, other lawyers as well, that these would generally be premises claims. But keep this in mind. If you're following the guidelines that we discussed, this would be very difficult to win, because even if they can show, this is probably their biggest hurdle, showing that this visitor contracted the disease at your facility, and they'd have to show that, or at least preponderance of evidence, which means more likely than not that I got COVID from going to your store. That's going to be very difficult to do. Contact tracing in the U.S. is not as tight as it is, let's say, in South Korea. So that's going to be very difficult to do. But even if they did that, it doesn't mean you're liable, right? Because you have to have breached your duty. You've not taken the steps you should have taken to minimize this risk. Well, if I'm following the CDC guidelines and the OSHA guidelines, which we just covered, which aren't onerous, aren't overly detailed, and even if you can show, which would be very difficult, that I got it at your facility, you're likely to lose because I'm following the guidelines. I didn't breach any duty. So I wouldn't be, especially if you're following the guidelines, I wouldn't be too worried about this. But I do think also, even if you haven't been, or you weren't in the past and you are in the future, following the guidelines, and someone comes in and says, hey, look, I got COVID and it was from your store. Again, keep in mind the hurdles I just discussed. They have a very difficult road to hoe to get home to get home for their case there, to show that they got it at your facility, and that's going to be very difficult to show. Very unlikely. Let's take a poll really quick. Have you had a customer or visitor claim that they contracted COVID at your premises? All right. Most people reporting already. Let's stop it there. So if 18, about 2/3 of people reporting, and 100% no. So that's great. So That's good news. Let's see, share the results. There we go. That's good news. Hopefully that continues to be the case. But again, if we follow the guidelines, even if someone comes in and claims it, even if they can prove that they did, you can still have, I believe, good protection by following the guidelines. So let's hope that doesn't happen. But if it does, I think you have a good understanding of what you can do to maximally protect yourself. Of course, call your insurance carrier if that happens. That's obvious, but always helps to mention. Okay, next section. What about liability to employees? This was more interesting. So the first thing you probably think of is, isn't this workers' comp? And the answer is yes, probably. If you're a workers' comp subscriber, now again, in Texas, workers' comp is not required. Workers' comp insurance is not required. But if you don't subscribe, you have other problems that we'll discuss later. You basically have a disadvantage in the lawsuit if and when you're sued for an employee's work-related injury. So again, workers' comp is a no-fault, employer-funded insurance for work-related injuries. Now, this includes occupational diseases. So here's what's going to turn on. Is COVID-19 an occupational disease? And I'm going to read you the definition, and we'll do a poll to see what you guys think. Would this be considered an occupational disease? I'm going to read straight from the Laborers Code. It says that it's a disease arising out of and in the course of employment that causes damage or harm to the body. The term includes a disease or infection that naturally results from the work-related disease. The term does not include an ordinary disease of life to which the general public is exposed outside of employment. So you kind of have two categories: occupational disease, something directly connected to the work, and other ordinary disease of life, which is saying this is just general exposure to the general public. It's not because of your employment per se, like the flu or a cold. Here's some examples of what's been deemed to be an occupational disease, not an ordinary disease of life. So pneumonia, tuberculosis, and other respiratory diseases which follow as a result of sudden accidental inhalation of heavy volumes and concentrations of noxious gases or other foreign substances which cause damage to the lungs. Sounds kind of similar to COVID, but the key thing there is it really related to my work, though? So it affects the lungs, pneumonia, TB, et cetera, respiratory diseases, but connected to the work. Here's something that's been rejected. Illnesses like cold, sore throat, pneumonia, even if sometimes the exposure to those elements clearly traceable to your job. Now, just based on that, take a quick poll. Would you consider, if an employee contracted COVID at work, would you think it would be an occupational disease or not? All right, we have majority of people responding already. A few more seconds here. Okay, so let's go ahead and end it. So it's 80-20. 80% of people would say probably not. 20% would probably say yes. So let's go back, talk a little bit further about that issue. There we go. So I think the way to think about this, and from what I've read, this seems to be the majority opinion on it, is that if the employee's job put them at a higher risk than the general public, then it might be considered an occupational disease. An easy example would be those high-risk businesses I just mentioned, healthcare, treating people. So that would probably be considered occupational disease, right? Now, I think if you tie this logic we're talking about here with the OSHA guidance, if you're contracting it at a low-risk environment, like maybe an office, probably ordinary disease of life, right? It's just community spread. I'm just doing it. I'm just got it just because I'm living in the world. And it's not because I work at Ramey Flock necessarily. Okay, very, very high risk, probably occupational disease. High risk, and I'm going back to OSHA guidance as far as classifying the business as high risk. Again, likely to be occupational disease. The key one I think to think about that would be more difficult is, what about a medium risk business? General public's coming in. Are you at a higher risk? I would say you probably are at a higher risk, but is it sufficient to be considered an occupational disease? So the employees then have to show that it's a producing cause of the illness, that the work is a producing cause of the illness. In other words, you got it at work and because of work. Here's an interesting thing I found just at the end of last week. Texas Mutual, one of the biggest workers' comp insurers, has said they will treat COVID claims on a case-by-case basis by looking at where the employee contracted COVID and whether the job carried a higher risk. So that's very similar to what I just mentioned. But here's a key takeaway from that. it seems that they're going to treat at least some COVID claims as occupational diseases. They wouldn't have put out that guidance saying, well, we're going to look at it case by case and look at these factors to determine whether it is or not. They would, it'd be more likely for them not to say that if they weren't going to treat at least some. I would think of it as combine that with OSHA guidance. If you're in medium risk, it may be possible, but again, you have to tie it to an employee that's specifically at higher risk. Just because I work at a medium risk business doesn't mean I'm in a higher risk position. I have to show I got it at work, all the same problems you talked about before. The good news, though, is that workers' comp is the exclusive remedy for employees' work-related injuries. So they have to go through, if you're a workers' comp subscriber, they have to go through workers' comp. If through that process it's determined that it's not an occupational disease, ordinary disease of life, you're golden, you're fine. You're going to be okay. If they try to bring a lawsuit and without going through workers' comp and you're a subscriber, you should be able to get it dismissed because workers' comp is the exclusive remedy for work-related injuries. Now, I'm not talking about gross negligence here. That isn't covered by workers' comp. So that's when there's an extreme risk and you're consciously aware and indifferent. The only scenario I can really think of where that would be the case is you have someone who tested positive, or like you're the business owner and you test positive and you just show up to work and just don't care. And I'm going to keep doing my work. I'm not going to tell anybody and you get people sick. I don't think that's going to happen. I'm just trying to think of a scenario where gross negligence could be the case. There's some workaholics out there, but I think nobody's going to do that. But anyway, gross negligence is outside of workers' comp. Don't see that happening. I think you're going to be workers' comp analysis, their occupational disease. Now, what if you're a non-subscriber? A little bit more of a problem, because the downside of being a non-subscriber in Texas is you don't get the contributory negligence defense. So in other words, you can't point the employee and say, well, it was partly your fault because you didn't follow X, Y, Z, or you didn't mitigate the risk yourself by being more careful. Now, in a lot of cases, that would be a very bad result, because a lot of times a worker, an employee may be mostly at fault sometimes for their workplace injury. And if you don't have that ability to put, percentage fault on them, and again, if they're 51% at fault, there's no recovery for them in a normal lawsuit. But if you don't get that option, which is the downside of being a non-subscriber, that's difficult. So again, if you're a non-subscriber, go back to the negligence analysis we've already done about visitors, essentially, be basically like that. Now, again, if you're following the guidelines of OSHA and the CDC, et cetera, I think you're going to be pretty safe. So I think that's your best bet, and you would be able to put on evidence of that. Now, I still think your best defense would likely be, even in this situation, that the employee has to show that they got it at work. They contracted the virus at work and suffered damage, and that's, and it's not an ordinary disease of life. So I think you're going to be pretty safe, even if you're a non-subscriber, but you're less safe than if you are a subscriber, and that's to be expected. However, I don't think that the lack of contributory negligence bar, the fact that you can't make that defense in these lawsuits, is going to hurt as much as it normally would have for a typical workplace injury, let's say falling off of a ladder, et cetera. I think that it's not going to hurt his employers as much as it otherwise would have, because of the difficulty of the employee showing what they need to show to prevail. So last one is OSHA retaliation I want to talk about when it comes to liability to employees. And we'll get into some other areas of refusal to work and furlough issues in a second. But this one, I could see this one coming up. I had a case recently that this came up. So it wasn't COVID related, but OSHA prohibits retaliation by an employer against an employee who complains about safety. It could work like this. I work for you and you're a restaurant, and I come to say, hey boss, I don't think we're doing this right. I think this is unsafe. Okay, you're a complainer, you go home, and maybe I'm rude about the way I even make that request. You took an adverse action against me. It could be OSHA retaliation. Again, that's a dangerous thing, right? Take adverse action against an employee based on a complaint. Now, they have 30 days. The employee has 30 days to report it to OSHA. So that's a very quick turnaround in the legal world to make this complaint to OSHA. Now, here's where I think it could come up, and this is going to tie into the refusal to work here in a second. And under OSHA, there's no general right afforded to the employee to just walk off the job or not come in due to unsafe conditions. If they walk, in other words, they go home and say, I quit. Because see, what could happen is they do that and say, well, that's the adverse action. It's like a constructive discharge. I made a complaint, they didn't change, and I went home, and that's essentially firing me. And then I didn't come back, and they fired me. I said I quit. So they could try to spin it as an adverse action. But if OSHA's for them to be justified in doing so, there must be a real danger of death or serious injury and insufficient time to eliminate that danger through the normal channels of, like, maybe making a complaint and then maybe adjusting the way workflow is done, et cetera, whatever the remedy might be. And the employee must have actually sought correction from the employer. So if I'm just going to say, I don't feel safe, I'm going home, that's not going to cut it. You're going to have to make a recommendation, basically, and you have to give time to actually follow the recommendation if it's compliant with the guidelines. This is a potential blind spot of retaliation. I don't see it happening very much. In fact, in the case I dealt with, the guy made a complaint generally about safety, went home. He, within 30 days, made his complaint, but we were able to, the investigator found that actually wasn't, there was no adverse action because the man was unjustified in basically quitting his job and walking off the job. It wasn't, imminent threat of death or serious injury. Now, contracting COVID can be for some people, but just be mindful. If an employee makes a safety complaint, that should ring a red flag. Watch out for OSHA retaliation. Next poll question, I think, is let's go to the next one. There we go. Have you had an employee complain that your safety precautions are insufficient in any way so far? All right, we have most people reporting. I'll go ahead and stop here in a second. All right. So looks like almost 90% no and 10% yes. So again, good results. I'd like to know how you handled it. You probably handled it well. I mean, but because good thing about a lot of stuff we're talking about, if you handle it in a common sense way, you're actually kind of following the guidelines. That's not always the case in law, right? But in this case, I think if you handle it in a common sense way, you probably protected yourself. So that's good. Not many complaints from employers. Now, what about refusals to return to work? So again, kind of building off what we just talked about. So in general, the refusal to return to work due to just general anxiety about COVID is not protected in any way. And if I'm just saying I just don't feel comfortable going back into work because I'm scared of getting COVID, there's no disability, there's no specific safety concern I have about my employer not following guidelines or anything like that. And this is coming up, and I've been told, and it makes sense to me, that a lot of times it's, well, I'm getting pretty favorable unemployment benefits. I'm not really in a hurry to come back right now. So in that situation, they're generally not, there's no protection for them. I mean, if your employer tells you to go back to work and you say no, you don't come back, it's like job abandonment, So generally, they're not protected. But again, remember OSHA retaliation. If I'm home, I'm calling in and saying I don't feel comfortable coming back, and here's why. I don't feel like you followed the guidelines, or I want to have a separate workspace. Again, doesn't mean you have to agree with them and actually incorporate what they're requesting, unless it's what the guidelines say, then you want to do it. But again, worry about OSHA retaliation a little bit there, but just consider it. I mean, generally in this situation, the person is going to be not protected. Now, we all know about the FFCRA, one of the many new acronyms in our lives: CARES Act, FFCRA, PPP, all this other stuff. But FFCRA, this was an early piece of legislation, and what it allowed, early during the COVID crisis, it allowed 80 hours or 2 weeks, 10 days of reimbursed protected leave for certain situations. Now, this is employers under 500 employees. That's the vast majority of companies, right? So it gave a delineated list of reasons that would qualify. So in this case, a person gets leave, their job's protected, you pay them for the leave, and you can get reimbursed through your payroll taxes for the leave you paid out. So if the employee is under a quarantine or isolation order, which we all were for a little while there, recommendation by a healthcare provider to isolate or self-quarantine, if the employee is symptomatic and seeking a diagnosis, if they're treating someone at home who has COVID, that's another example, and this one comes up a lot, your school or childcare is closed due to COVID. Now, all those, except for the last one, you get 10 days, 2 weeks, 80 hours of paid reimbursed leave, and your job is protected. So again, if the person is not coming back, but they fall into one of those categories and they haven't used their FFCRA leave yet, then again, be mindful, give them their leave. Now, once it's over, the job is not protected anymore, and we're back to square one that I just mentioned. Now, the school and childcare issue, and again, that's it's reimbursed and it's paid leave, but it's at a reduced rate. It's at 2/3 the regular rate, but they get up to 12 weeks actually in that case. I won't get into the details, but basically the first 2 weeks is more available. The next 10 weeks, because it falls under FMLA essentially. But even if you're not an FMLA employer, this still applies to you. So I don't mean to be confusing. That's just the way it is. I think 12 weeks though, at a reduced rate for the school or childcare closure. And then we run into the problem, which I've run into many times, is how do we verify that? I mean, you kind of have to take the employee's word for it to a certain degree, even if you may have other information that would say, I'm not sure that's totally accurate. You want to give them the benefit of the doubt. It is reimbursable after all. Now, here's a potential blind spot here, though, for FFCRA leave, is that the statute says it's good to the end of the year. So you may have had all your employees back in the spring use all their FFCRA, and you think, well, that's out of sight, out of mind. I've already done that. I've been reimbursed. I'm good. What about new employees? What about people who start in the fall? And again, keep this in mind. Also, what about someone who used 1 week of it, and then they're talking about maybe a second wave of COVID in the fall, et cetera? Keep this in mind. This will probably still be in place, and I mean, of course, the way it's written out, it will be in place. And if somebody hasn't used all their leave, or if they're a new employee, keep in mind they may be FFCRA protected if someone's requesting off. Next is ADA disability. So again, these are exceptions to the general rule, but if an employee has an anxiety disorder, that can be an ADA disability. And if they're saying, hey, look, and think more of like diagnosed situation more so than just, again, the general worry wouldn't be. But if you have an anxiety disorder, and there's many of them, and especially if their doctor's saying, hey, I don't recommend Eric coming to work because of his anxiety disorder, that should ring a red flag, right? Because even if you're not FMLA, if you have 15 or more employees, you have to comply with the ADA. And so, hey, disability, this could be a reasonable accommodation. So if that's the case, additional paid leave or unpaid leave, or telework, flex scheduling, all those things could be reasonable accommodations that you don't, again, you have to make a reasonable accommodation for a disabled employee to fulfill the major essential functions of their job. So again, in this situation, you want to think about these accommodations. And here's an example of one. I mentioned my example earlier of, let's say 20% of my job is I have to be in the office, 80% I can do telework. Maybe if I have this disorder, maybe a reasonable accommodation would be that 20%, maybe move that 20% in the office work to maybe another employee for a few weeks or a few months, whatever, and I just do my 80%, or maybe give me more work I can do telework, kind of shift work. That might be an accommodation. Always recommend this. I think it's a great site. EEOC recommends it too. Go to askjan.org, askjan.org, Job Accommodation Network. You can type in different disabilities, and I'm not good at brainstorming, so I'll give you a list of things you can consider. Document that you've done that. You're doing your due diligence. So anxiety disorders should raise a red flag as well. We have a little bit of time left, so let me ask this question. Have you guys had an employee refuse an offer to return to work yet? All right, most people have responded, so I'm gonna go ahead and stop it. This one is a little bit more balanced, right? About 65-35, yes to no. So this is happening more, and I can tell you I've seen it firsthand a few times myself. So this is an issue coming up. Just go through the process. If you're an employer who has to comply with FMLA, then I would do this. There we go. Go through your general certification process. So if you're FMLA employer, I highly recommend requiring medical certifications for the leave that's requested. Use the Department of Labor forms. Give that to the employee. They have 15 days to get it back to you, filled out by a healthcare provider, and that's going to answer the questions on that form that you need to determine whether it's FMLA covered or not. I won't get into the details of that, but know that obviously it could be FMLA related if it's the underlying condition that is putting them at higher risk for COVID. It might be a serious health condition. It might be an issue where you get the certification paperwork, and if it comes back and the healthcare provider fills it out and it doesn't qualify for leave, fine, but you've done your due diligence. That's only employers over 50. What about unemployment? So unemployment, if they refuse to return to work, are they going to get their unemployment? Again, generally no, but there are some guidance from TWC that explains that they're going to be a little bit more lenient. So if you have refused to come back to work, you don't feel safe, and you're over 65, you're at higher risk, TWC says you're likely to get your unemployment benefits. If you have a household member who's at higher risk, so let's say my wife is 70 years old, in that situation, the employer has done nothing wrong by saying come back to work, and if you can't, we can't employ you, okay, but that employee is going to get their unemployment benefits. If you're diagnosed with COVID, if you have a family member diagnosed with COVID, if you've been quarantined or sent home for 14 days for exposure, your child care is closed, the same cast of characters. Now, the good thing about this, though, is that TWC's come out and say, well, look, we're not going to charge back the employer for COVID-related unemployment claims. So that's very good. So it shouldn't be any harm to the employer, but just know if you get unemployment claims from employees who have refused to return and they fit these categories, don't be surprised if you get the result back that they were granted their benefits. When you didn't fire them, they quit. That could still be the case. Let's hurry up here. I have a few more minutes. Okay, furlough concerns. So many employers have furloughed workers, and that phase of selecting who to furlough is probably mostly past unless things get worse in the future. But when you're selecting who to furlough and who to bring back, be very mindful of the alphabet soup of discrimination claims, because again, if you're selecting people for furlough at a disproportionate rate, so pay attention to the demographics, it could very well look discriminatory. Think of a reduction in force. I know that's not technically what it is, but it's very similar to that. So pay attention to demographics and make sure you're not being discriminatory in any way when you're selecting who to furlough and who to ask back. So that asking back part is, I think, a potential blind spot. So again, reminder: age, race, religion, sex, national origin, somebody making a workers' comp claim, FLSA complaint. If I've made a wage and hour complaint against you and say, hey, I think I'm not paid overtime right, it's like, oh, time to select who to come back. I'm not going to select Derek because you made that complaint. That could be retaliation. So be mindful of that. What's the best way to protect, though? One, be mindful of demographics, of course. Be mindful of anyone who's made complaints about maybe harassment, discrimination, wage and hour, workers' comp. I'm not saying you can't put that person on a list that's not brought back, but here's the thing. We want to have documented reasons why people are selected to come back or selected for furlough. And so that's going to make us as businesses sit down and really think about and analyze better who we're selecting to either be furloughed or be brought back. That's number one. Two, it's a contemporaneous note and document saying, here's our reasoning why. That's very helpful for defending a lawsuit. Believe me, if you're contemporaneously right now, here's the reasons why we selected Eric to come back, but not John to come back. That could be great, unless those reasons are discriminatory, which they're not going to be, right? But keep this in mind too. This is what I mentioned at the beginning. This is a blind spot, because if you're saying, well, we're going to ask people to come back from furlough and we're going to ask people who are at lower risk of COVID, well, that sort of makes sense, but what's going to happen? Possibly ADA disability discrimination, possibly age discrimination, possibly sex discrimination. So you may be thinking lower risk, but those demographics are protected. So be very mindful of that. You don't want to select people to return for furlough in a way that's going to be discriminatory. Lastly, just two very quick things. One is you want to report refusals to work to the TWC. They're keeping track of who's unemployed and who's not unemployed. And if they've been offered to return to work and they refuse, notify TWC. And lastly, I didn't get into much of this because this isn't what this presentation is about, but if you've offered someone to return to work and they've refused, and you have a PPP loan, you probably already know this, but document that. Put that in writing. Document the offer to return and the refusal, because it has to do with your loan forgiveness. So the general rule of forgiveness is basically the ratio of people you have on your payroll during the period you use the money compared to prior periods, basically. But if someone was laid off in the spring, you offered them to come back. If they come back by June 30th, they won't necessarily count against you. But if that person refuses, what you do? If you document it in writing, the SBA said a few weeks ago, they won't count that person against you as far as your loan forgiveness ratio. So that could be a very good benefit. So looks like I'm about at 52 minutes here. So I thank you all for your time. I wish I could get more interaction and feedback, but I hope this covered the main concerns. These are the main concerns I thought of, at least from an employer standpoint. And I hope this was beneficial.
Thank you, Eric. Eric, you'll stay on with us. We've had some great questions.
Sure.
It was so much wonderful information. Thank you so much. So let's get back to a couple of the questions that we received. Hold on just a second. Let me get to our main screen here. Okay. All right. Let's see. Q&A. One question that was asked. This is the time of year when a lot of people are going to be going on vacations. And so what is your recommendation for when to allow people who have been traveling, maybe in airports, that type of thing? What would be the best practice for allowing them to return to work?
Well, from what I've seen, I would treat them the same way we're talking about. So if they're symptomatic, we go through the symptomatic issue. If they're potentially exposed just from going to an airport, I haven't seen anything. There were some travel restrictions information earlier on, especially if you're going to higher risk places. I would say maybe if you're going to a higher risk place like China or Iran, etc., you may want to actually treat that person 14-day. I know there was a ban on like Louisiana travel. I'm from there, so I kind of thought that was funny for a while there for 14 days. But if they're going to a higher risk area, you may want to go 14-day, wait, see if you're symptomatic. But I think general travel, I think it would be okay.
Okay, great. Another question that was asked is, can you take the temperature of customers? In this organization's case, the adult students who come to a class.
That's a good question. You know, full disclosure, I didn't look up that answer. I didn't see an answer, but I would lean toward yes. I would lean toward yes, but I'm full disclosure, I don't have a firm answer on that.
Okay. Let's see. Is the 10 days of protected leave, is that at the employer's expense?
It is at first, so it's sort of a cash flow issue. So you pay it first, and then you get reimbursed via your payroll tax filings with the IRS. So you should be fully reimbursed for it, but you pay it out now, and then your quarterly or annual, depending on how you file, I guess, you would get reimbursed via your payroll taxes. Should be in full from the IRS.
Another person asked, Susie asked, how will a scenario that you described earlier work in a school environment? For example, the employee is sent home but can't return to work for 3 days.
So that's like a teacher, let's say, maybe?
Perhaps, yeah.
Okay. So I think if that's the case, if it's a teacher that's sent home, I think you have to work with a substitute or shifting a schedule. I don't think there's any way around that.
Okay. And then there were a couple in the chat box. Let me just double check and make sure there were no other questions in the chat box. Let's see. Oh, here's one. Okay. And then let's see. Sorry, I need to expand this thing. Okay, here we
go. And I see, real quick, Michelle, I just looked up and saw Nancy Crawford's question about, is it 3 consecutive days? Yes. Of no symptoms.
Okay. Let's see. Sorry. Okay, given the broad range, Carol's asking, given the broad range of symptoms associated with COVID, what is your recommendation on when an employer should allow an employee to return to work after they have called in sick with symptoms that could probably be COVID related? However, the employee doesn't seem to suspect that they have COVID.
Yeah, that's a good question. So if they're having symptoms that are in the COVID category, and we all know that there's many other illnesses that have similar symptoms, right? But coughing, shortness of breath, fever over 100.4, I would apply the rule very strictly, right? So 3 days, no symptoms, 10 days since first symptom. Even if they're certain, look, it's definitely not COVID, it's something else, I would apply the rule just the same.
Great. Okay, those, if we didn't get to all of your questions, we will get those over to Eric, and if you would like more information, we can also get your information to him. Eric, we had several people ask if we'll be sharing the PowerPoint presentation. Would you be able to do that?
Yeah, no problem. I can do that.
Okay, great. So for everybody who's attended, we will be sending you the link to the YouTube replay of this video. Sorry for the music at the beginning. We were trying to make a really nice experience and it worked last time, but I guess we won't be using music next time.
It gave me a dramatic entrance, so I'm okay with it.
Dramatic entrance. And basically I was just talking about you and talking about how you also are a jiu-jitsu and a wrestling champ.
Champ.
So you kick
no.
butt in the courtroom and on the jiu-jitsu and wrestling mats.
No, I'm the victim. I'm the victim on those mats.
So thank you all for joining us. We've got lots of webinars for all of you coming up. We've got one on June 25th that's hosted by the BBB of Central Oklahoma, just to kind of check where you are 6 months in and make plans for the rest of the year. And then we're hosting another one on July 6th. Our speaker and author, John Grubbs, who is an employment expert, will be speaking to all of us on July 6th from 11:30 to 12:30. Again, you will all be receiving links to all of these webinars and our YouTube videos, so feel free to watch this again and share them with your friends. Thanks again for joining us, everybody.